Good afternoon. This is Justice for All, and I'm your host, George Yates. We're going to be here today for the next couple of hours with Professor Brandon Garrett. He's a University of Virginia law professor. He's an expert on wrongful convictions, and he's also an expert on corporate prosecutions. He's been a professor at the University of Virginia since 2005, and he's recently written a book which is just coming out, and the name of the book is Too Big to Jail. Professor Garrett has compiled a vast database of all the prosecutions against corporations in America over the course of the last 10 to 15 years, and as an expert, and has been cited by the United States Supreme Court and many other courts as an expert in corporate prosecutions. We'd like to welcome him to the show today. How are you doing, Professor Garrett?
I'm good. Thank you for having me.
Well, you know, your book, thank you for coming on the air. It's a real thrill to have you. You have quite an interesting resume. For those of you that have just joined us, this is Justice for All. And we have Professor Garrett here today. He got his start. He went to Yale and Columbia Law School. And he got his start working for the folks that started the Innocence Project, Barry Scheck and Peter Neufeld. And after he was an associate with that firm, you clerked for a federal judge prior to being an associate with the Scheck firm. Is that right?
Yes, I clerked for the Second Circuit, the Federal Appeals Court. I clerked for Judge LaValle. It was the year of 9/11, so it was a year the courthouse was closed. There was all kinds of security. We were working right across from where the Trade Center was. It was a real interesting year to be a law clerk.
Well, you've written some other books besides this. We'll get to the Too Big to Jail book, which is just coming out. But you've written some other books, right?
The other book I wrote is a book called Convicting the Innocent, Where Criminal Prosecutions Go Wrong. And I'd been working for Peter and Barry, the founders of the Innocence Project, but I was working for a civil rights firm where we sued for victims of police brutality. We also sued wrongful conviction suits where people got freed by DNA. We tried to get them compensation. But I hadn't worked at the Innocence Project. I didn't know a lot about what caused wrongful convictions. And so I went back and gathered the original criminal trials of the first 250 people freed by DNA to go back and do an ongoing study of how did they falsely confess, how did eyewitnesses get it wrong, what types of forensics were presented in those cases. And so there's a lot of data gathering over a lot of years, but I could not just tell individuals. We've all read some of these individual stories when someone gets walked off of death row or walked out of prison serving 20 years. But I wanted to really carefully study the trials where they originally got convicted. So that book came out in 2011.
Now, we had on our show earlier this year, we had Nick Yates, who was freed after 21 years on death row in Pennsylvania, and he wrote a very interesting book called 7 Days to Live. And wow, that was a fascinating interview. Do you know Yates?
I've met him briefly, and I corresponded with him because I was getting records in his case. I've read his entire trial, written about his false confession. It's an amazing case. It's one of these cases where the police couldn't get anything particularly incriminating on tape, but they claimed that he had said stuff to them before they started the tape, when they were just talking informally, that he had said things which included details that only the murderer could have known. And we now know that he couldn't have known those details. He didn't know those details. He was innocent. But it goes to the danger of not taping an entire interrogation so there's a clear record of who actually said what. And that's a big issue in Virginia right now. Not that many agencies in Virginia videotape interrogations.
Well, the false confession cases are, most people would just believe, well, nobody's ever going to falsely confess to something that they didn't do. I mean, and that's the general mood, I guess, of a jury. And that's what happens in these cases. I guess they have some false confessions. How do you, when you're working to achieve an innocence, how do you throw out a false confession? How do you get somebody? Do you have to use DNA? If there's just a false confession and nothing else, it's pretty hard to have them exonerated, isn't it?
It is. Well, it's amazing. What I've been seeing is that there's been a kind of a second wave of DNA exonerations with false confessions, and most of these cases are more recent cases where the person was convicted even though the DNA cleared him at the time of trial. They were convicted anyway. Basically, the confession trumped the DNA. And it was only later when the DNA got a hit in the database to someone else. They could say, okay, not only does the DNA clear me, but here's the other guy who actually did it. It took that to free those people. The fact of the confession somehow trumped the DNA, even though there was no particular explanation for why the DNA didn't match him. Really troubling cases.
And are you still working on behalf of the Innocence Project as part of your professor duties?
Well, I don't do work for them directly, but I still do research on these DNA exoneration cases, and so I share, my data with them, and they share data with me. Although I am working for them in one sense. I'm doing a fundraiser. I'm running the New York Marathon in a couple of weeks, and I'm doing it as part of the Innocence Project charity team. Since I do give charitable donations to them each year, and this year I'm going to do that plus run 26 miles. So.
Wow, that's great. I ran the New York Marathon once back in '88. I ran it, and
well, you probably actually qualified, but my times aren't good enough to get in any other way.
Well, I tell you, I interviewed Bob Fisk on our show a few weeks back. The great lawyer from New York, and he'd just written his memoirs, prosecutor, defender, counselor, and he talks about running the New York Marathon. And I think to me, and you're going to notice this, when you cross over that 59th Street Bridge and you start coming into Manhattan, and there's just thousands of people at the bottom of that bridge, and when you start coming down that bridge, you feel like you've just won. You won the Olympics. It's the greatest. And then you start turning up First Avenue, and that's when it starts getting hard because you're starting to hit that 18, 19, 20 mile mark. But right when you're coming over the bridge, it's only about 15 miles, so you're still feeling pretty good, 15, 16 miles. And they got all the music going. That's a great event. Well, good for you. That's going to be really fun. Your work on behalf of you've done some work in the eyewitness testimony area. Tell us about that. Clearing, a lot of these people that are exonerated later, they were picked out of lineups, or somehow there was faulty eyewitness identification. Tell how that happens and what you have done, because my understanding is that you are working with with Virginia and with the Department of Justice in Virginia and the police department to have eyewitness identifications done more fairly, so that more people are not wrongfully identified. How are you doing that?
Well, there's a very good model policy in Virginia for how to do lineups right. And in fact, there was big news in this area last week, just last Thursday. The National Academy of Sciences, which is the leading scientific institution in the country, brought together a group of scientists, and I was honored. I was part of the committee. It's a committee product. They issued a report on the science and research on eyewitness memory. It's called Identifying the Culprit. It's almost book length. It's not a book, but you can read it for free online. It's called Identifying the Culprit, Assessing Eyewitness Identification. And they talked about what the science has shown can prevent eyewitness errors, and some areas where also the science is still really in dispute. But one thing they highlight is that eyewitnesses' memories are really, really delicate and even malleable. You can shape an eyewitness's memory. We all think that, okay, maybe it's not easy to remember the face of some stranger. But, we're all good at remembering faces, or at least better at remembering faces than someone's clothing or their height. And there is something distinctive about faces. We think of, though, a lineup as the way that police test your memory. And so if something really horrible happens, maybe you were trying as hard as you could to concentrate on the face of that stranger. If you got a decent look, well, the lineup is a way to test it. And so, you have some extra fillers there, including maybe the suspect, but also some other people. And so if your memory isn't so good, then you'll flunk the test. You'll pick one of the fillers. What people don't realize is that the way that the lineup is done can actually change your memory. It's not just a right or wrong test. It can actually change your answer. And there have been these exonerations where I've studied where the victim eyewitnesses have come forward later and said, I wasn't sure at first, but then when they gave me these lineups, they gave me these cues, they told me what a good job I did. All of a sudden, I became more and more sure that this guy was the one, even though I was really shaky at first. And they start to develop this false confidence and ultimately identify an innocent person in court with complete certainty that that's the guy who did it. I'll never forget that face. And so that's what was amazing to me reading all these DNA exoneree trials, that this certainty with which these eyewitnesses would point to the guy in the courtroom, that's the one, I'll never forget that face. It's burned into my mind. When actually they were kind of shaky at the time of the lineup. They weren't sure. Some of them weren't even sure they could ever identify a face because it was so dark and they never got a good look. But by the time of the trial, they were all sure. And so one of the key things is to make sure the lineup is done blind by an officer who doesn't know which one is the suspect. You just have to bring in a different officer, or you can put the pictures in folders so that the police officer can't see what the eyewitness is looking at. And that makes it impossible for the officer to say, oh yeah, take an extra look at that one, or even just to sort of hesitate and pause or sort of look expectantly at the eyewitness. You don't want any of those cues, whether they're unconscious or not, reinforcing the confidence of an eyewitness. So that's one of the key things that scientists have been recommending. And unfortunately, most agencies in Virginia don't do it. And there are a bunch of other reforms, making sure you ask the eyewitness how confident they are in their own words, since by the time of trial they'll be absolutely sure. They might not be at the time of the lineup. But most agencies in Virginia don't document that. And so it's been frustrating to see how long it's been taking in Virginia to get that change made. There's so many cases that involve eyewitnesses, and making these changes to the way that lineups are done isn't really expensive. All you have to do is put the pictures in folders or write down the confidence of the eyewitness. None of this really costs anything. It's taken a frustratingly long amount of time to get these best practices in place.
Well, now, isn't it a fact, though, that if they've already made that identification, that these procedures are probably not going to be known or transparent, right, to the defense attorney? I mean, if you've got a defense attorney that's defending this case, how do they go about finding out whether or not it was? I mean, obviously they can cross-examine during preliminary hearing, I suppose, of the arresting officer, whether it was blind or not. And but how would they know, or how would the fact that there were these cues given ever be known to somebody trying to defend against a wrongful identification?
Well, if there's no careful documentation made of what happened at the lineup, there's no way for the defense lawyer to know. I mean, some of these,
it's not like
some police departments now videotape lineups so that there's a real record of what happened. But most in Virginia don't do that. It's recommended now that these procedures be videotaped. That's what the model policy in Virginia says. But I only know of a handful of agencies that actually do it. The ones that do it say it's really valuable for them too, because sometimes an eyewitness looks at that picture and immediately that's the one. And that's helpful evidence for the police. But obviously it's not helpful if the person is sort of hesitating and takes 15 minutes and is looking at everything 3 times. But you want a record of that. You don't want someone to be doing process of elimination and looking at every picture for 5 minutes. I just don't know. And then at the end of a half hour saying, oh yeah, that's the one who did it. And then go into court saying, that's the one who did it. Or you want to know that this person was actually really shaky. And everyone should know that. But if there's no record made, then there's no way to find that out.
So these people that you've gone and you've found out that these cues were used, was this after maybe the person was exonerated and then you were able to go back and ask them how they made the wrong identification? I mean, for someone to come back after the fact and say, gee, I was wrong, is that how that happened? Is somebody that knew they were wrong and now they're going back and trying to figure out how they could have gotten it wrong?
No, it's actually even more amazing than that. What I found when I read these trials is that most of these eyewitnesses at the criminal trial, admitted that they had been really shaky and uncertain. They said, today, yes, that's the one. That's the guy. I have no doubt in my mind today. But they would actually admit that when they saw the earlier lineup, they weren't sure. They were hesitating between 2 different people, or they picked out a filler at first, or they told the police they didn't think they could make an identification. I was amazed how much of the time the eyewitnesses actually admitted openly at trial. They remembered having been really uncertain, but then they became certain.
And these were cases that you went back and researched after when you saw there was DNA evidence that exonerated, and so you knew that the person didn't do it, and so therefore let's go back and see. Well, that's fascinating. Now, if someone's going to be defending this, or if you're called upon to assist somebody in the defense of this sort of thing, have you ever testified as an expert witness on this? Or there are people out there that actually are eyewitness identification experts. They'll testify for the defense as to how unreliable this technique is? There
are. People testify for the prosecution, too. I think it's important for for a jury to hear about the science behind eyewitness memory. A lot of it is not common sense at all. People might think that, if you're under stress, you're going to pay close attention. And the research suggests that if you're under stress, it's much harder to remember faces. There's a lot of research on cross-racial identifications and how much harder it is to identify faces of another race. And so it's important to have a social scientist who really knows this research explain some of this to the jury. And in fact, this scientific report that just came out from the National Academy of Sciences strongly recommends that judges allow experts to explain all this to a jury. And there's some scientists in Virginia, plenty on the East Coast, that do this research and to testify. In Virginia, it's really up to the judge whether to let this in or not. And some judges seem to entertain it and some don't.
So the model rules which you have proposed for Virginia going forward for eyewitness identification, have they been accepted in certain, in Charlottesville, for instance, where you teach law?
Yeah, so there are a number of jurisdictions that have adopted the model policy. I helped to work on it, but so did a lot of other people, law enforcement. It was the Department of Criminal Justice Services, which is a state law enforcement services agency, that puts out model policies for police in Virginia. And it's not binding. There was actually a law passed in 2005 because there have been so many of these DNA exonerations in Virginia that had eyewitnesses. A law passed in 2005 that says if you're a police agency, you have to have some written policy on lineups. Didn't say what the policy had to be, but you have to have some policy on eyewitness identification. And everyone assumed back then that departments are going to do the right thing. They'll follow the model policy. There was one at the time. And departments didn't. There's still to this day, there are agencies that don't have any written policy and aren't following the law. And so in 2010, they thought, this is not good. They wanted to update the model policy, make sure it was really good, and also get the word out there that you really had better follow this. And some of those efforts were made. The model policy got redone. I heard from some students who were planning to do a Freedom of Information Act. I guess they'd already done it. I was trying to get examples of law enforcement policies, having approached the Virginia Chiefs Association. Students, meanwhile, apparently had FOIA'd every single police agency in Virginia, which was a huge FOIA job and a big pain. But they shared what they found with me, and I read all of these lineup policies from all across the Commonwealth. And, only a handful of agencies were following the model policy. Most of the policies were really short and not very good and years out of date. But some departments like Charlottesville, like Roanoke, I think Virginia Beach may be one of them too, have had blind lineups in place for years. They've been doing good lineup procedures for some time now. But there are an awful lot of agencies that haven't changed the way they do lineups in 20 years. So it's a real mixed bag. I really think that there should be legislation to require agencies to follow whatever the current model policy is. But there's a real frustration that it's taking so long to get these practices in place.
If you've just joined us, this is Justice for All. I'm George Yates, and my guest here today is Professor Brandon Garrett. He's a University of Virginia law professor, an expert on eyewitness identification procedures, and he's also just written a book called Too Big to Jail, which details really the history of prosecuting corporations in America. And before we move on from this eyewitness identification area, Professor Garrett, I just like there's I just was noticing Marvin Anderson. Tell us about the Marvin Anderson case. You worked on this case?
I haven't worked on it, but I've read his trial.
He was exonerated by DNA testing, and was convicted solely on the basis of a victim's eyewitness testimony.
One of the really amazing things about his case is that when the victim was shown some sets of photos, these kind of six-packs of several photos, one of the photos she looked at before she got to Marvin Anderson's photo was in a set of pictures. One of the pictures was the guy who actually turned out to have been the culprit. Years later, DNA matched him. And she looked right at his picture and didn't pick him.
Wow.
The picture of Marvin Anderson, the police, I think maybe because he had no prior record, they didn't have a mugshot on file for him. So they went to his workplace and got a picture, which was like a workplace ID that was in color. And his was the only color picture. The others were all black and white mugshots. So his obviously stood out, and the victim picks him out. His picture stands out. It's the only one in color. And actually, his lawyer sensibly tells the judge, you can't let this eyewitness identification in. The victim picked him out because it was blatant. He was the only color picture. And the judge says, I don't see anything unfair about that. They're all similar pictures. Let it in. It's really unusual to see a judge ever take an eyewitness identification away from the jury. But here's an example where not only was it really suggestive how his picture stood out like that, but the victim looked at the actual culprit's photo and didn't pick him. That's how easy it is to do these lineup procedures wrong and really alter someone's memory. She looked at the guilty guy, kept moving on, and then she sees this color picture which sticks out like a sore thumb, and she picks out this innocent man.
It's surprising to me that it's so easy to get these convictions with eyewitness testimony, really, because, how many of us just will mistake somebody walking down the street all the time, right?
You start to say hi to someone, and then you realize, that's embarrassing. I actually don't know that person at all.
It happens all the time. It happens once a week to me, where you'll see somebody that you think you know, and then you get closer, and it's not them. Or you'll see somebody, you say, you look just like somebody else, and this is somebody you've never seen before. And it's remarkable that I guess maybe they do it because is it because they get these victims to say I'm 100% sure, and that because by the time they get to court, they've got them so confident that they point them out, and the jury just has they're so sure. Is that what you usually have found in your research?
Well, almost without exception in these cases, the eyewitnesses were absolutely sure, and there's research done on jurors who absolutely think that confidence means the person is right. People figure, I might say hi to the wrong person walking down the street, but I'm not totally sure that I know that person. If someone is standing in front of me and says, I'm absolutely sure, I was concentrating, I'm totally sure that that's the stranger who did it, I think people think about that in a different way. People think that confidence is related to accuracy. And it's not at all related to accuracy. What we suspect is these eyewitnesses are confident because police have been telling them that they're doing a good job. Or it's really easy to be confident when you pick the only color picture out of the photo array. Right? It was an easy test, and you feel really good. Oh, I did great on the test. And it was just an easy test. But
and you say there's
you also wonder. Let's say you bring in an expert in to explain to the jury, look, just because someone is confident doesn't mean that they're accurate. Eyewitness memory is delicate, and confidence isn't the thing you should be looking for. These are the things you should be looking for. Could be that the jury will still ignore the expert and say, oh, no, that was the victim of a crime who was trying really hard to pick the guy out. This person has no motive to frame anyone. These are well-intentioned people trying to solve crimes. I don't buy the expert. I think the guy did it. I could see that happening today. People may trust their own intuitions over science.
And you say that there's a model policy that's been written. When you say the model policy, is that in the law book somewhere, or this model policy on how this should be done with the videotaping and the blind, where another police officer that doesn't know anything about the case actually conducts it, so there's no cues? Where is that model policy to be found?
It's written by the Virginia DCGS, Department of Criminal Justice Services, and they make them available online. But it's not legally required. The law says you have to have some written policy, but doesn't say you have to have a good one. And so this is just a recommendation from this agency in Virginia. So, I'd like to. There was legislation introduced last year to make it more than a recommendation, require agencies to follow it, but it didn't go anywhere in the House of Delegates.
Right.
Sheriff Harding, an Albemarle County sheriff, and some other police have been working with me to push this idea. Sheriff Harding has really taken the lead on this, and he's been spearheading it. We need a justice commission or an innocence commission in Virginia to really work on all these reforms. The legislation just doesn't seem to happen. Improvements just don't seem to be moving very quickly. And somehow, despite all these wrongful convictions, nothing's changing. So his thought is we need an innocence commission or a justice task force, call it whatever you want. And apparently it's being considered. We may hear some more over the course of the year. There was real interest from the head of public safety and from the attorney general who we met with to talk about this idea, but so far nothing's happened.
Well, let's just say that there's a small jurisdiction. Could you say that Virginia Beach is now following the model policy in some ways?
I think they're one of the ones that was. I think that maybe they've been doing blind lineups for some time now.
So a jurisdiction has to have a written policy. What if they don't? What if somebody's trying a case and a lawyer is trying to defend it? And I've just got a couple of minutes before the break here, Professor. So we'll just do a quick answer. Maybe we can take this after the break. But what's a remedy? What is the remedy to the lawyer or to the defendant if, in fact, they have a written policy and they have not followed it? Is the judge going to throw out the eyewitness identification based upon the fact that the police department has violated its own policy or doesn't have a policy?
The judge may do nothing at all.
Right. So there's really there's no real teeth to it, right? I mean, there's a law that says you have to have a written policy, but if they violate the law, there's no remedy, right, for the defendant that's been violated.
Nothing happens, and in fact, even when we went back to the legislature last spring and said we want the law to just change it by a sentence, say you have to have a written policy that complies with the Department of Justice model policy. All the people on the crime subcommittee said, "Oh, no, then eyewitnesses could have their testimony thrown out of court." And we said, "No, there are no teeth here. We're just saying that departments have to do it. We're not saying that there's any consequence." They said, "Oh, no, we think judges will start to throw out identifications. We couldn't possibly ever have a law like that." So just the notion that any eyewitness might someday not be allowed to testify in court, no matter how weak that eyewitness was, the eyewitness could have been blind and drunk and admitted that he couldn't see anything. Still, the concept that any prosecutor would suffer the least bit of consequence from putting on unreliable evidence was enough to make the crime subcommittee folks say, "Oh, no, we could never do that, not in Virginia."
That's just a really scary, and I really appreciate the fact that you're actually going and trying to get this procedure changed, because something has to be done. We're going to take a break here. This is Justice for All. I'm George Yates. We've been here with Professor Brandon Garrett. It's a very interesting interview so far. We look forward to the rest of the interview with Professor Garrett. We're going to take some breaks here. We're going to come right back and discuss more about eyewitness testimony and corporate prosecution in America. We'll be right back.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their two locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today. Hi, this is Greg Bigaveris. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM.
All right, we're back. This is Justice for All. I'm George Yates. My guest today is Professor Brandon Garrett. He's a University of Virginia law professor and we've just finished our first half an hour here. We've been talking about eyewitness testimony, and for those of you who've just joined us, we were talking about the science behind eyewitness testimony and how flawed eyewitness testimony can be, and how many people have been convicted just based upon the testimony of an eyewitness, and then later on were exonerated by DNA evidence. And Professor Garrett has done a lot of research into these types of cases, both after working at the Innocence Project and after being a law professor at Virginia for since 2005. In our last segment, he mentioned a National Academy of Sciences report called "Identifying the Culprit." Just came out last week. So for those of you out there that are interested in this sort of thing, you can download that. It's free. It's from the National Academy of Sciences, called "Identifying the Culprit," and it has all the latest science in misidentification. And how eyewitness testimony can go wrong. And Professor Garrett has been instrumental in trying to draft Virginia, and he's also tried very hard to have all the localities in Virginia adopt a model policy so that each jurisdiction adopts procedures that will make sure that witness identification is accurate and is not prone to have the wrong people convicted of crimes based upon flawed identification procedures employed by police departments. I'd like to thank Professor Garrett for being here with us today. But we're going to turn, Professor, you've just written a book, Too Big to Jail. Tell us about it. How did you begin this idea for writing a book called Too Big to Jail? What's it about?
Well, I first started looking at how corporations were settling their prosecutions with federal prosecutors not long after I started at the University of Virginia in 2006, 2007. And I noticed that some of the biggest companies, real big names, were settling their criminal cases almost entirely out of court. They started entering these deferred prosecution agreements, non-prosecution agreements, basically the kind of thing you'd give to a nonviolent offender where you say, look, if you stay out of trouble for a year or 2 years, if your drug tests come back clean or whatever, then we'll just dismiss the charges from the docket. Nothing will happen to you. There'll be no conviction. It's often done for juveniles or for nonviolent offenders. It's not done very often, though, in the federal system where, you talk about a federal case, a real serious case, big sentences. It's not often that federal prosecutors let someone off the hook without a conviction. And yet these some of the largest companies that were engaging in frauds and the like with, hundreds of millions of dollars in fines, they were paying hundreds of millions in fines, but they were entirely avoiding the regular criminal consequences. And all that happened because there was a concern after Arthur Andersen went under. Prosecutors were worried about destroying companies. They didn't want to destroy companies. They just wanted to fix them. And so I noticed these agreements early on, and I started collecting them, making them available online, and trying to study them to see if there were any patterns. And it turned out I was onto something. It wasn't just a passing fad or anything. Each year there have been more and more of these agreements. Most of the public companies, the biggest companies, get them. And I also started looking at the companies that get convicted, that don't get the special deals, that plead guilty. And it turns out some of the ones that are convicted also get lenient treatment in one way or another. They often don't get fined as much as they could have. And so I now have this big online collection of what I hope is every federal corporate prosecution, or just about every one, since 2001. And I decided a few years ago that with all of this data, and I'd written a little bit for law review articles, but I wanted to write a book for everyone to understand what happens when a company gets prosecuted.
And where did the title Too Big to Jail come from?
I thought it would be a witty way of getting to the idea that you literally can't put a company in jail, but you can punish it, and corporate companies can absolutely commit crimes. It was a play on too big to fail, which was the concern after the financial crisis that some financial institutions were being let off easy since we couldn't afford to have any of them go under at risk to the global economy. So there was the concern that regulators won't get tough with these institutions because we know that they're crucial. Well, the same concern applies where you worry whether prosecutors are going to use kid gloves if it's such an important company to the economy that you just can't afford to kill it.
Right.
And it doesn't just come up with banks. There was a case involving a hospital in North Carolina. No one wants to destroy this big community hospital.
Right.
You don't want to jail or death sentence a hospital, but if it's engaging in fraudulent billing practices, you want to make sure that people are punished and that something is done about it. It comes up for pharmaceutical companies. The big pharma companies, they typically settle criminal cases as misdemeanors because no one wants to get them debarred or thrown off of Medicaid. People can't do without medications from these big companies. They need the medicine. But you also don't want that to be a license to the companies figuring, okay, we can commit whatever crimes we want. No one's going to touch us.
Right. What we see, and I do work in all courts, all the way from the traffic to juvenile domestic relations up to federal court. And it is interesting how they're treating these corporations like they're children, because if you have a 17-year-old that gets a DUI, you know he gets a chance to get a deferred finding in juvenile court, and you know, if he goes into rehab and does well, he can actually have that off of his record and actually get the charge dismissed. But he has to jump through some hoops. He has to go through some he has to go do some community service and do these kinds of things and that he's supposed to do. So it sounds like that's the new approach to treating corporate misconduct, to treat these corporations like they're children, that they're just we're trying to fix them and not punish them.
Yeah, you kind of wish actually that more offenders were treated in a way where you're trying to actually rehabilitate them,
right,
and not just punish them for the sake of punishing them. It's just a little ironic that it's the most privileged offenders who literally can't do jail time that are being treated this way when a lot of individual people that did nonviolent things aren't getting the benefit of that.
Yeah, you started, and I'm trying to figure out what your do you feel that this is a good policy or a bad policy overall? Do you think that this has been a good development, that that corporations are not being punished like they used to be?
Well, it's both good and bad, and the reason it's complicated is that before prosecutors started doing these deferred prosecution agreements and the like, they were just afraid to prosecute companies at all. And in the past, you just didn't see many companies prosecuted, period. The fines were usually pretty low when they did it. Even before there were separate sentencing guidelines for companies, the company would be sentenced the same way as an individual. And so you'd have a company where there was a massive fraud and they would pay like $10,000, right? It was a minor slap on the wrist type thing. And so you've seen corporate fines explode. All of a sudden, you know, you hear about billion-dollar fines in the newspapers these days. There are multiple billion-dollar fine cases just this past year. And so that's a really good thing. Corporate crime really is being treated more seriously. We don't see more cases being brought, but prosecutors really are demanding much more punitive fines. Prosecutors are also I think, right to focus on shaping up the company and not just fining them, because the fine can be passed on as a cost of doing business to the shareholders and to everyone else. My concern, though, is that prosecutors are throwing so much leniency at these companies. It doesn't have much teeth if you can just pay a fine and move on. Prosecutors say, oh, yes, our goal is to reform the company, but they mostly keep these deals out of court, away from a judge. There's no one reviewing it, no one approving it, no one supervising it to make sure the company is actually following through on its promises. And as a result, the cases are treated as kind of criminal light, and we're starting to see big companies, big banks even, that are recidivists, that are getting prosecuted multiple times, and nothing seems to be changing. And that really should trouble us. If some of these most serious corporate offenders really aren't mending their ways, then they shouldn't be treated like kids anymore. All of a sudden, if you're a recidivist, something different has to be done.
Well, what do you attribute that to? Politics? I mean, are the lobbyists in Washington for the banks just telling the executive branch not to go? You know, I mean, because this is a judicial. This is I guess the Attorney General, right? I mean, this would be United States
Attorney General, but each U.S. Attorney's office
right.
has a fair amount of flexibility and freedom. And,
sure.
And actually, you know, U.S. attorneys have every incentive to bring as big a case as they can against a big company. They want a track record of, if you
right.
want to be a successful prosecutor, you want to bring big cases and
right.
win them. And so, you know, if you want to be hired by companies to defend you against corporate crime cases down the road, it's really good to have worked on some big ones as well. And so I don't think prosecutors have any incentive to drop these cases. One tough thing about them, though, is that, you know, these companies can hire entire law firms to defend them, and they do. They can bill hundreds of millions of dollars, more than the cost of, you know, entire criminal defense systems of whole states. And, you know, you might have, in a big case, a few prosecutors assigned to it, up against an entire law firm. And the prosecutors, you know, how are they going to find out what happened inside this company where there are all kinds of documents and emails and could be thousands of employees? You can't talk to all of those employees. You're really depending on the company to turn itself in and to tell you what really happened. You have much more in the way of resources to investigate these cases. That's the best you can do. You can make life easier for the company if it cooperates, but you're going to be depending on the company to give you the documents and to tell you what happened and when. There's a real power imbalance in these cases. You don't normally think of prosecutors as the little guy.
You really don't.
That's the way it works here.
You really don't. It's just absolutely fascinating. I had Richard Gabriel on my show several months ago, and he was on the trial team for O.J. Simpson. And back in those days, a lot of people thought anyway that O.J.'s had all this money. And he hired a dream team, and it was only because of his dream team that he was acquitted, and this sort of thing. But as Richard Gabriel mentioned, the fact is that the state of California had a heck of a lot more money than O.J. Simpson did, and they spent millions more on prosecuting O.J. Simpson than he spent in his defense. So, in the end of the day, there is no one single individual criminal defendant that can ever, be a bigger gun than the government. But you're telling me that these corporations have more resources than the government, and that is a really interesting observation, and it's fascinating.
There's a company, the Siemens company, the big German multinational company, spent over $1 billion doing internal investigations, hiring lawyers, and in some ways they absolutely outgunned the government. I mean, they hired entire law firms, accounting firms, but the government leveraged it cleverly, right? They were giving Siemens credit for cooperation, so Siemens was literally spent $1 billion uncovering the full extent of its own wrongdoing and turning itself in. And that's an amazing kind of jujitsu.
Yeah,
if it works, you really give the company the incentives to clean house and investigate itself. But obviously, the government could never mobilize those kind of resources to really find out what was going on inside a company.
It fascinates me. I noticed that in your book you mentioned that Jeffrey Skilling, let's go back a little bit to some of these earlier cases. Back in the old days, they did, during the dot-com crisis, we did prosecute individuals. We prosecuted Bernie Ebbers. He went to prison. We prosecuted Jeffrey Skilling and Ken Lay, and, they were convicted. Skilling went to prison. And then they did prosecute Arthur Anderson. The difference was in Arthur Anderson, which you detail quite well in your book, and this is a fascinating thing for people that haven't followed this, but Arthur Anderson, they prosecuted Arthur Anderson. They convicted Arthur Anderson, destroyed the company in the course of the prosecution. Then later on, the conviction was thrown out. But by that time, Arthur Anderson, the whole company had been destroyed. And I think is that when the tide began to turn in your mind, that they said, we can't just destroy companies. We have to try to, is Arthur Anderson the turning point in your opinion?
Yes, it was shortly after that case that the Department of Justice rethought the guidelines they use, sort of factors they give to prosecutors to consider when deciding how to prosecute a company. And so the Arthur Anderson trials in 2002 and early 2003, they rewrite their guidelines to encourage the use of these deferred prosecution agreements. Of course, Arthur Anderson goes out of business not really exactly because of the conviction. They paid a $500,000 fine, but they could afford that. It wasn't the conviction exactly that did it. It was really the collateral consequence of the conviction. The SEC had rules that if you're a convicted felon, you can't do accounting for public companies, and that's what Anderson's business was. But the SEC could have been more flexible about that rule. They weren't willing to give Arthur Anderson any breaks, since they were under investigation by the SEC for 3 or 4 or 5 other things, other shoddy accounting involving Sunbeam and a whole bunch of other big accounting scandals. And so, Arthur Anderson was in trouble for bad accounting at multiple giant companies. It wasn't just Enron. And, it's maybe not a good example because it wasn't just the one conviction that did it. They basically had so many problems and were involved in so many accounting misdeeds that the SEC wasn't willing to cut them any breaks. That's somewhat understandable. Apparently, and in some ways, it was a partnership, and so it's not like a regular company in the sense that it's just made up of partners. The partners could all leave, and so they all left and went to other accounting firms. The company just sort of dissolved with all the accountants going different places. Not exactly the same thing. There are a lot of companies convicted every year, and most of them don't get dissolved. Most of them don't go out of business. It's only when you have this unusual situation where the company loses its ability to do business as a consequence of a conviction that there's this fear that the prosecution might destroy the company.
If you've just joined us, this is Justice for All. I'm your host, George Yates, and we're here with Professor Brandon Garrett, who is an expert in corporate prosecutions, and he's just written a new book called Too Big to Jail, which is available on your newsstands now and your bookstores and on Amazon. And Professor Garrett, I'm interested in going back to the big question. I think the question of the day is, why have there not been any prosecutions coming out of this meltdown from the 2008 mortgage crisis? I know there was an article in the Times just last week. Joe Nocera, he wrote an article calling it "The Hole in Holder's Legacy," and he found that Eric Holder did a lot of things as Attorney General. He reduced prison sentences and he expanded civil rights and so on, and has some good things on his record, but that there was a gaping hole in his legacy, and that is that he did not bring any of these individuals that may have been responsible for this mortgage crisis, financial crisis. He didn't bring any of them to justice. What's your take on that? How do you feel about that comment by Joe Nocera, and why haven't there been more prosecutions, in your opinion, of individuals?
Well, to start where I start my book, I do have information. I have information about all these prosecutions of companies over the last decade or more. And when the company gets prosecuted, normally individual people don't. And so only about a third of the time when the company gets prosecuted are individual officers or employees prosecuted as well. And it's really unusual cases like the Bernie Ebbers WorldCom case where the CEO or someone really high up actually gets targeted. And that's absolutely the type of person prosecutors most want to hold responsible. They want to hold the higher-ups responsible, not a bunch of underlings. It's just not that common for it to successfully happen in these cases. Now, there's thousands and thousands of people prosecuted for fraud every year in federal court. It just so happens, though, that when the company settles the case, employees are often not targeted. And in one way, you'd expect, well, wait a minute, the company is settling a criminal case. It's agreeing to cooperate. The prosecutors can get from the company any emails, any documents. The company can hand all that stuff over. You'd expect that to be a real easy case to figure out who did what and to go forward. Normally you don't have a cooperator like that. A company is kind of like the ultimate snitch. A company can give you every document you want. But even still, with the company's cooperation, you see a lot of these cases, nothing goes forward against individuals. And one of the real challenges in these cases is that companies are complicated. Authority is divided. People specialize. And if it's, let's say, a securities fraud case and some statement is made to the public, which turns out not to have been true, well, that press release may have been approved by 60 different people who all signed off on it. Do you prosecute all of them? Does the more senior executive who ultimately makes the statement, can he just say, well, I just read the press release. Other people typed it up. 60 people approved it. I just read what they told me. I was depending on them to give me the information. In a lot of these cases, it's really like a nasty culture of breaking the rules. That's the problem. But it really is genuinely hard sometimes to figure out who did what and whether there's one particular evil villain, mustache-twirling villain who's responsible. Sometimes there really is the mustache-twirling villain. And, insider trading cases, there have been big cases like that brought where there are people giving inside tips. And there's a guy giving a tip to a stock trader who's making money off of it. That's a clear case where someone is doing something intentional. Or there are antitrust cases where someone gives, fixing prices with their competitor. They're calling each other up on the phone and they're fixing prices. That looks like a nefarious scheme. Or there are these LIBOR cases. They're fixing interest rates, calling each other up, asking for favors to fix the rates. Right? That it's really easy to show who did what. But when you have a company with terrible policies and it was letting bad decisions fall through the cracks, there could be a lot of people responsible. And maybe you could try to prosecute all of them. But it can be really difficult to go forward if you just really don't know whether or not there was any one person that was really planning it. And that's something that prosecutors have said in these cases, that we just don't, to show a fraud, for example, you have to show intent. You have to show an intent to defraud. We're just not sure if we can show that when, it was just a terrible culture in the company. We want to fix that culture. We're just not sure if we can blame any one person.
Well, I was, for those of you that have just joined us, we're here with Professor Brandon Garrett, and he's written a book called Too Big to Jail. And really, his book, it appears to me, Professor, that you first assembled this vast database of all of these corporate prosecutions. Is that fair to say? You had students and other associates assist you in assembling this vast database, which is online and available to the public, right?
First thing, right, there's no corporate offender registry. I just wanted to know how many companies are convicted, how many companies settle prosecutions each year, what are the crimes, what are the fines. I just want to know basic information about what happens to companies that are prosecuted.
And what
because even just that wasn't available.
Right, and so what you did was you went and you assembled this vast database, and then from that you wrote your book. Is that fair to say? You assembled the database first, and then after you assembled all this data, you said, okay, now I'm going to write a book which will kind of, to some extent, summarize what you discovered in the course of your research? Is that how all that worked out? Is how the book...
That was how I started. I really started from the ground up.
Mm-hmm.
But there are a lot of unanswered questions and features of these cases that you just don't know from reading the documents. And I try to give a picture of what it's really like when a company settles on these cases. Because it's one thing to read the agreement. Sometimes it's just very boilerplate.
Right.
We will pay $300 million. We agree to cooperate. We agree to install an excellent compliance program. And so for some parts of the book, I went behind the scenes a little more, and I talked to some of the monitors and lawyers working on the case, or I dug into transcripts to hear what the people were actually saying about what happened at the company. Because, a lot of what we get in the public about what, obviously companies don't want to talk publicly about a really, really bad criminal scheme that their employees were working on.
When I was doing some research to get ready for your show today, I read your book, and then I saw your database, and I went and I just said, I'm going to go ahead and pull one of these plea agreements. Actually, I'm fascinated by it. I'd love to pull a bunch of them and read them, because I think you've got all the plea agreements available, right, to review on the website?
Yeah.
And what is that website?
Yeah.
So for anybody that's listening, what is that website? How does one go ahead and download? Can they just go to your name, Professor Brandon Garrett, and get that information?
Yeah. The easiest way to get it is from the University of Virginia Law School website. If you click on my name, there's some links to it. Or if you go to the law library, you can get it from there too.
Okay. We've only got about one more minute, so we're going to take a short break here. And when we come back, I read through, there was just one case that I pulled up, Professor, and it was a little food mart, apparently, in Georgia that somehow was selling the precursors to methamphetamine, knowing full well that, all the stuff that they were selling was going to be used in the manufacture of methamphetamine. And yet, a corporate drug dealer, and instead of manufacturer, and instead of prosecuting those people individually, they just signed a plea agreement with the corporation, which was then going to, I guess, pay a fine under the guidelines. I'd like to come back after our break and ask Professor Garrett about these kinds of agreements and how in the world these individuals don't get prosecuted. This is George Yates. This is Justice for All, and we'll be right back with Professor Brandon Garrett right after this break.
Hi, this is Greg Bigoveris. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM. The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their two locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today.
All right, we're back. This is Justice for All, and I'm George Yates, your host, and we're here with Professor Brandon Garrett, if you've just joined us. And we were just talking about this corporation that was apparently pleading guilty to selling methamphetamine, or the precursors to methamphetamine. This is just a case out of Georgia. And I'm just wondering, Professor, if you don't know whether or not when these people, when they prosecute the corporation, whether or not they also might prosecute the individuals as well.
I know that for the deferred and non-prosecution agreements, and those are some of the biggest companies. So I've looked at those, and I've looked at public companies. How often do their officers or employees get prosecuted? But for the smaller mom-and-pop companies, it's really hard to find that out, since sometimes the dockets aren't connected. You don't know whether any individuals were targeted or not. There may not be any news reports about it. With the big public companies, there are news reports. It's easier to find out. And so I focused on the biggest companies, the ones that are getting the out-of-court deals, public companies. And for them, the public companies, only a quarter of the time officers or employees were prosecuted. For the whole group of companies getting these out-of-court non-prosecution deals, only a third of them had employees prosecuted. And that's just a prosecution having been begun. Plenty of those cases were dropped. Some resulted in acquittals. These white-collar cases, people say, bringing more cases against Wall Street bankers. Well, some of those cases, prosecutors have had high-profile losses, and there are more acquittals than you'd expect in a typical federal criminal case in these cases. More cases get dismissed, more acquittals, plenty of losses by the prosecutors. A big chunk of these people don't end up doing jail time. They pay a fine, they do probation.
Well, that's right. I mean, the Joe Nocera article mentions that those traders from Bear Stearns were a very high-profile prosecution, and they were acquitted. And
these cases, sometimes it's the particular thing that made it fraudulent is really hard to explain. It's technical. When it's that they're breaking certain accounting rules, or that's not always easy to explain, and it might depend on what everyone is supposed to know about the accounting rules and the fact that these people were doing stuff that they should have known better. But that can be very difficult, and sometimes there are millions of pages of documents. It's really, really difficult, detail-intensive stuff. The question in these cases is typically, was a crime committed? It's not like your typical street crime case where the question might be, was it self-defense, or is this the right guy? There's this real question of, is what was done a crime? Is it fraud? Did it fool someone? Were you intending or scheming to do a fraud? Or, it's not a crime to just do something risky in your business, or to make a bad business decision, or to, negotiate hard with a competitor. You don't have to, if you're negotiating a deal with someone, you don't have to tell them everything. Business people all the time say, "Oh, this is a great opportunity. You should really invest with me." Right? That's not a crime. That's not fraud.
Right.
At some point, it crosses the line, and you're actually doing something which is totally deceptive. But especially the more technical the subject matter, the more people will try to argue, look, this tax shelter, they call it a total sham tax shelter. I don't think it's a total sham. I consulted lawyers, and they all reviewed everything. We showed our accountants, our lawyers, we showed our experts. Everyone told me that this was fine, and that's why I did it. And when you have that kind of situation where we ran it by the lawyers, we ran it by the specialists, now you're telling me it's a crime?
So is that when the government comes to the corporation, or the corporate lawyers go to the government and say, well, it's a close case, so why don't we just agree to a deferred prosecution? Is that how it does it come out as somewhat of a plea agreement that way, because it might be a close case?
Certainly, that's what some of the corporate lawyers would tell you, that our companies are just getting pressured into settling these. Mm-hmm. Maybe that's why no individuals are prosecuted. We're not sure they could have proven a crime anyway.
Right.
We settled it just to put it behind us because we just didn't want the government breathing down our back. And obviously, the government's view may be very different. The government's view may be, no, there were serious crimes committed here. We can't figure out who did what. The company gave us a lot of documents. We're not sure they gave us everything. We're not sure we're hearing the whole story. But fine, we'll settle it. And some of both may be true in some cases. In some ways, there's no way to ever know, because it's a whole group of people in a complex organization. The truth may never quite come out. Of course, you really do legitimately worry in cases where individuals are prosecuted? Is the company throwing some of its employees under the bus? Were they the ones really responsible? Is the company just trying to settle the case and move on, and we have to fire and send a few employees to jail, but the company prospers? You worry about that too, since the prosecutors are so dependent on what the company tells them. Since it's really hard to figure out who did what.
Well, that's going back to the Arthur Andersen case, which is really the first case in your book, Too Big to Jail. There was a fellow in that book, I think his name is Duncan, and he worked for Arthur Andersen, and you get into some of the law as to, you got a company here, and maybe you can answer this question for us, and we'll get in a little bit in the details of the Andersen case, which led to some of these other changes. Duncan actually pled guilty to his name's Duncan, right? And he pled guilty.
Yeah, he was the head of the group that was working for Enron.
And then right. This was all for those of you who just joined us. We're here with Professor Brandon Garrett, and we're talking about his book Too Big to Jail. And we're going back to Arthur Andersen. Arthur Andersen's crime. Everybody remembers Enron, and Arthur Andersen's crime was that they were the ones supposedly cooking the books for Enron. So
their crime was a little different. That wasn't what they were prosecuted for.
Well, they were prosecuted for obstructing justice, right? And while they were under investigation for shredding documents, which may well have shown that they were cooking the books for Enron, right? Is that fair to say?
Yeah, all of a sudden when they're at the investigation, they get a letter from the SEC saying basically, we're interested in what you were doing with Enron. But no letter from the SEC saying, give us your documents. They hadn't been subpoenaed. The subpoena is sort of the document from the agency saying, give us your records. We are demanding legally that you provide the records. Instead, they got a letter saying, okay, you're of interest to us. And the minute that they get that letter, all of a sudden there are all these meetings led by high-up people like this guy Duncan. Lawyers are involved, big meetings, big conference rooms full of Arthur Andersen employees. And everyone is told, by the way, carefully adhere to our document retention policy. A document retention policy. No one had even heard about the document retention policy before. It says something like at any company, you don't save everything forever. You want to clean up your files, save the important stuff, you can throw the rest away. They had some files like that are key documents explaining what work you did, you need to save that. Unnecessary stuff you can get rid of. But it seems like, no one had ever had a meeting before where they reminded people about the document retention policy. The message seemed to be getting out that get rid of Andersen stuff. And all of a sudden there's this enormous spike in the deliveries to their document shredders in Houston. Normally there'd be, a certain number of bags of stuff that they would send out to be shredded. All of a sudden, like tons of paper are being sent out in trucks every day to be shredded. So it looks pretty bad. And then the minute they get that subpoena from the SEC saying, we are legally demanding documents, all of a sudden the message goes out, stop the shredding, stop the presses, stop. And so they argue, well, we weren't legally being asked to give documents, and we were complying with our document retention policy, and we weren't doing anything wrong. So the question was, did they know that they were under investigation, basically? Were they doing this intentionally and corruptly to hide documents from the feds? And that's what the case was. Obviously, the standard is if an employee has committed a crime, then the company is liable for that crime. It's a strict standard. It doesn't have to be a high-up employee. It can be any employee. So it's a tough standard in federal law.
It sure is.
And David Duncan says he's pleaded guilty. And so the prosecutors might feel pretty confident. Okay, this guy admits he committed a crime. He says he obstructed justice. Now we convict the company for obstructing justice. But it turned into a complicated trial because to obstruct justice under the way the statute was written then, you have to corruptly persuade other people to help you. And they were arguing, well, who is he corruptly persuading? Who was listening to him? Was it really corrupt? Were they just trying to clean up their files, or they were just nervous? Were they really long trial with expensive lawyers? There are protests outside the courthouse. We are Arthur Andersen. We are people too. Are you going to destroy this whole company because of some stuff that a few employees did? Maybe they panicked, but maybe they weren't trying to obstruct justice. They really put the whole company on trial, saying, it's just not fair to blame us. And we don't know. It could have just been a bunch of people running around like chickens with their heads cut off, panicking, but not intentionally trying to. It's not like obstruction of justice where you're threatening to kill witnesses or destroying documents on purpose. These are a bunch of nerdy accountants. They were just they were just in a fright. That was kind of how it went.
Well, and the fascinating thing was here's Duncan on the stand testifying against his company, saying because at one point they were going to pay his legal fees, and then I guess they cut him loose once he formed his deal with the government. But there he is up on the stand pleading guilty, but at the same time the lawyer for Anderson is cross-examining him, saying, you're really not guilty, are you? You really never did try to...
You've been sort of convinced into... the government has convinced you into thinking that you're guilty.
Yes.
And actually later on, when the Supreme Court reverses the case against the company, he says, you know what, I thought that what I did was a crime then, but maybe it wasn't. And they allow him to basically take back his plea.
And he withdrew his guilty plea. This is one of the Anderson's got to be one of the most amazing stories to follow. Even because he withdraws his guilty plea and they dismiss the charge years later.
They do.
And so after this, we've got this. I guess more and more of these. I guess deferred prosecution agreements, or prosecutions where the companies come in, plead guilty, but they don't get serious problems associated with that criminal conviction. After Anderson, which I think is the most interesting of all of these cases, it seems to me. What other cases kind of stuck out for you, Professor, that were the most interesting, or the ones that you had the most did you find any that you had disagreements with, that you thought they got off too lightly, or there was something that just seemed to not, add up? I mean, you've done a lot of research here.
Yeah, well, just in general, it's been upsetting to me to see how often these companies are getting these deferred or non-prosecution agreements where there's no real risk that they're going to get put out of business like Arthur Andersen. And so why not have it be in front of a judge who can make sure that they're really paying an appropriate fine, make sure that they're really doing what they're supposed to do to shape things up. Some of these companies have been recidivists. They've committed one crime after another.
Name some.
And you wonder whether they're really just being let off too light. You may remember in the book I talk about BP.
Right.
And a really, really tragic story about an enormous explosion at their refinery in Texas City, Texas.
Right, in Texas,
And a number of victims and their families, hundreds of people injured, a number of people were killed in the explosion, and there had been every kind of compliance problem at that refinery. People have been complaining for years that things weren't being fixed. Sort of a perfect storm of bad upkeep. And it wasn't, they had bought the refinery not that many years before. They sort of inherited an aging structure. But there's a cost-cutting culture. We don't want to spend money on this. We don't want to spend money on that. And then this horrible explosion. The victims came forward when the company was being allowed to plead guilty for, fine in the tens of millions. Not a very big fine. And it was not a very big fine, especially considering that the company was sort of settling multiple environmental prosecutions. There was a big spill in Alaska. There are 3 different environmental crimes they're settling all the same year, all at the same time. They were a recidivist already, 3 different crimes. And the victims came in and said, we're not asking for more money. We've already brought our cases in civil courts, and we're settling our cases. We're not asking for money out of this case. What we want is accountability. We want this company to be put on probation, where the court will be monitoring them, and they should be fined more so that they really feel this one, because they're just going to do it again.
Now, this blow up in Texas, was this prior to the Deepwater Horizon disaster? Right. So it was
a huge I told you so, when just a few years later the Deepwater Horizon happens, and some of the victims actually did say, we told you so. We've been telling you that nothing was changing at this company, that you can't just allow them to plead guilty to 3 crimes, pay some slap-on-the-wrist fines, and not really watch over them. In fact, they later got fined some more because even at that particular refinery, they weren't fixing things the way they were supposed to be. They've now sold the refinery, maybe just giving up on getting that place to run right.
Well, now they were also convicted at Deepwater Horizon, weren't they? Did they suffer any criminal prosecution and conviction? 15 people died in that explosion.
They did, and that plea agreement looked very different than the one years before. And so, maybe they finally did get held accountable more like a recidivist. Mm-hmm. They paid a fine that was, at the time, the biggest criminal penalty in any case. They paid over $1 billion in fines, and another $3 billion in community service. So a company can do community service, but it was payments to study the Gulf, to bring scientists in to assess the health of the Gulf. So it was $4 billion, a big penalty. They also suffered something actually maybe even more significant than that for them. They were barred from any Gulf drilling contracts with the government for more than a year. And that was a huge hit to their business. To be suspended for that long, not just for a month or two, but for a whole year, was actually a very big deal for their business. And that was a stern warning. And other things happened, right? They basically voluntarily set up a $20 billion fund to compensate victims, and with really not too many strings attached. Now they've been suing to protest it and say, wait a minute, victims should have to be able to prove more that they got really injured in their businesses or whatever by the Gulf spill. But it did turn out very different when the Gulf spill happened. But you do wonder whether if those earlier prosecutions had been taken more seriously, maybe all that tragedy could have been avoided.
Well, is there any evidence that BP or has, I mean, as a condition of their criminal prosecution or criminal accountability, were they ordered to do anything differently? They're held accountable.
Most recent, in the Deepwater Horizon one, that was different. All of a sudden, there are two different corporate monitors. There's like a environmental compliance monitor. There's like an ethics monitor. Two different monitors to watch over the company over years. So that looked different too. There was ongoing supervision to try to shape things up.
Okay.
And so that's, I actually think those monitors are really important.
Now you talk about yeah, you do. You talk about monitors in your book. Yeah. And so you're saying that BP now has to have some monitors as a result of the the Deepwater Horizon disaster?
They do. And some people have criticized these monitors for some sensible reasons. In fact, early on when I was writing about this stuff, I testified in Congress twice because of big controversy surrounding now Governor Chris Christie. And he did things like his former boss at the Department of Justice, John Ashcroft, was appointed monitor in one of the cases. And he was billing a sort of a fixed retainer of almost $1 million a month. I'm not going to show you how much time I've worked on this. Just pay me $1 million a month. And that there was a lot of criticism that, wait a minute, are these monitors really doing any work? Prosecutors are picking their friends to, a lot of the monitors are former prosecutors. Is this just sort of like a government gig where you get paid a lot of money, the company doesn't really have any choice?
Mm-hmm.
Concerns about cronyism in the selection of these monitors, because these really are plum positions.
Right.
You get to hire, if you're going to do monitoring of all of BP, one person can't do that. You have to bring in a whole staff to do it.
And these monitors are not reporting back to the court or anything, are they? I mean, it's not like
I think they should be. In a case where there's a plea agreement, at least there is a judge involved, and the judge can demand that the monitors report back to them. Mm-hmm. And I think that's really important because you want to make sure that the monitor is doing real work and not just billing a lot of hours. So that a company could complain to the judge if the monitor really isn't doing anything or if the monitor is doing things that are unreasonable. But you also want, if the monitor uncovers more crimes, you want there to be a consequence. Hold the company in violation of probation. But when you do these deals out of court, if it's like a non-prosecution agreement, or a lot of the deferred prosecution agreements, judges haven't been involved. They've figured that this is a case that isn't really on my docket exactly. Then it's really just it's between the prosecutors and the company, and it's not clear what the consequences are if you're not shaping things up.
This is Justice for All. If you just joined us, I'm George Yates, and I'm here with Professor Brandon Garrett. He's a tenured University of Virginia professor who's just been doing research since 2005, actually, on corporate prosecutions in America, and has just written a book, Too Big to Jail, which is available now. And go out and buy it because it's a fascinating account of how corporations really are avoiding, in many cases, even being criminally convicted at all for what are corporate crimes. And they're getting what they call deferred prosecutions. And we've just been discussing the BP company, which had the Deepwater Horizon spill, of course, the Louisiana disaster a few years back. Professor Garrett, what other companies besides BP are stuck out in your mind as recidivists that continue to break corporate laws and get off with a hand slap?
Well, maybe it'll be no surprise to people that some of the major banks, some of the Wall Street banks and some of the big foreign banks have been prosecuted multiple times over the last few years. There was just a story in the New York Times this week asking whether if banks start to get prosecuted for being investigated, some investigations surrounding manipulation of foreign currencies, if those turn out to be, it sounds like they might be, some of the same banks that have been prosecuted for other things in recent years, are they going to be treated as recidivists? Or will it be argued that, well, but those are different crimes, different people did them, these are big institutions, we're not recidivists, we're not one person, you should take each crime on its own terms. It'll be really interesting to see that. Often typically when these companies settle a prosecution, they say, our prosecution will be deferred for 2 to 3 years. And during those 2 to 3 years, we promise we will not break any federal laws or commit any federal crimes. And if we do, then we'll be in breach of the agreement and you can go after us. Well, will these banks be held in breach of their agreements? There's a real question about that. That came up. There's the big bank Barclays entered an agreement, deferred prosecution agreement in 2010.
Right.
And while that agreement was still in effect, they were prosecuted for another set of violations involving the manipulation of this LIBOR interest rate.
Right, exactly.
And the judge said, could you please explain to me why this new prosecution isn't in violation of the agreement that I have sitting in front of my court, this deferred prosecution agreement in 2010? And the bank and the prosecutors both came forward and said, oh, no, it's different. This LIBOR manipulation actually occurred well before 2010. It's not a violation. Different type of crime, different people involved. We don't see any connection between the two. The judge was troubled, but he said, okay, if that's what you're telling me, I'll dismiss the prosecution.
So they're able to show that the conduct is not during the period of probation. It's actually from before.
So sometimes they can show that, or they say it wasn't similar enough, it's not fair to treat the company as a recidivist.
Well, if it was one of my clients, I think, and if they're out on bond for one crime and they commit another crime, it doesn't have to be
similar, right?
No, sir, it does not.
It's not like it's not like if you're a murderer, you can say, well, don't give me an enhanced sentence because of my prior drug convictions, because that was totally different.
Yeah, it doesn't matter if it's another violation of law. That is a violation of your terms of your bond. And if you're an individual, you go to jail, and if you're a corporation, you don't. And it's all part of the real serious perception in the country today, really, that the big and rich get a different treatment at the bar of justice than the little guy. And I think that's probably fair to say all the way through your research is you're seeing a lot of that. Is that fair to say?
Yeah, I mean, I think companies are different. They have to be punished somewhat differently. Sometimes you could have a rogue employee at the company, and it might not be fair to blame the whole company. You want to just put that rogue person in prison.
Right.
But if the company is really at fault, if the company was tolerating it, profiting from it, then you really need to hold it accountable. And I think people are right to be concerned that it seems like too big to jail. If a company is given this out-of-court deal where they're getting off easy, they're not getting convicted. We did start to hear some noises from the Department of Justice. Holder has been saying in speeches, too big to jail doesn't exist. There's no such thing as too big to jail. Look how we're insisting on convictions more often now. And I hope that's true. I hope they're starting to reconsider giving these out-of-court deals to companies. Since it turns out plenty of the time you can convict a company can plead guilty. And the deal can be structured in a similar way where they're paying fines, they're agreeing to reshape their practices to make sure it doesn't happen again. All that can be done with a conviction in front of a court without putting the company out of business. And so hopefully prosecutors will insist on that more often.
We are here with Professor Brandon Garrett. He's a University of Virginia law professor, and he's just written an informative new book, Too Big to Jail. This is Justice for All. I'm George Yates. We're going to take a short break here in a minute. We'll be back for our last 30 minutes with Professor Garrett, the author of Too Big to Jail. We'll be right back.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their two locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today. Hi, this is Greg Bigaveris. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1, right here on 1650 AM.
All right, we're back. This is Justice for All. I'm George Yates, and we're back for our last 30 minutes with Professor Brandon Garrett, a University of Virginia law professor and the author of Too Big to Jail. When we went to the break, we'd been talking about some of these recidivists, some of these companies that had continued to violate the law. You talked about some of these banks, Barclays in particular, and the whole LIBOR scandal and how they were manipulating currencies and interest rates and that sort of thing. And there, I guess what you want to do a lot of times is follow the money, don't you? If you want to find out where the crimes are being committed, is that what these prosecutors do if they're trying to prosecute corporate crime?
Well, yeah. Sometimes they get involved because they notice something suspicious, something just not adding up. There was a hospital billing case in North Carolina where it was sort of like following the money type analytics. They noticed this pattern of irregularities in the billing, and they realized that there was a crime unfolding. Some of these investigations of faulty trades or price fixing or collusion on interest rates come about because people notice that the numbers just seem off. Sometimes it's whistleblowers, though, too, where it's to take someone on the inside. To extend the Watergate analogy, it's not following the money, but it's sort of a deep throat character who can tell you something about what's going on inside. And because it's hard to get deep inside a complicated organization where people don't want to lose their jobs. They know that talking to law enforcement is probably not something their bosses will be excited about. A lot of the big cases have been made because of people sticking their necks out as whistleblowers, or just someone on the outside noticing that something just doesn't add up. One of the things that did happen in reaction to the financial crisis was the Dodd-Frank law includes these whistleblower provisions to give bounties to people who come forward and tell the authorities information that helps them uncover fraud. And I guess we'll have to see over time whether those whistleblowers really get rewards and really get protected in their jobs, because you don't want them to be retaliated against.
Well,
that's what sometimes it takes an insider to find out what's really going on.
And that's interesting. Being a whistleblower and actually being on the inside, because I noticed that. Do you find that when you've got these corporate prosecutions where there is a corporation being prosecuted and an individual, some kind of a conflict of interest where you've got the corporation is paying the attorney's fees, and of course they need to because the individual, I'm sure, can't afford attorney's fees themselves. But is there a conflict when these cases work that way, where you have an individual being prosecuted and also perhaps be at the same time the corporation is being prosecuted?
Well, typically, right. The company is being prosecuted separate from the employees. The company may just want to settle the case and put it behind them, but the employee may be facing. Employees are not too big to be put in jail. They may be facing real jail time, and so they may have pretty separate interests.
Right.
And so they may have separate lawyers. One of the most difficult situations is where the company may typically want to just give the prosecutors whatever information they want. They just want to cooperate, to pay a fine, and to make the case go away. So prosecutors may say, "Sure, tell us what really happened, and if you self-report this, if you come clean, we will absolutely reward you." And they should encourage companies to come clean. You don't want companies to hide misconduct. But that puts the employees in a terrible bind. So say the company says, "Okay, we need to find out who did what here. We're going to send our lawyers out to interview all of the employees that might have been involved and question them in a big conference room." And that's what will happen. And by the way, if employees refuse to cooperate with this investigation, they're fired. We don't need employees who are hiding stuff from us. We need to know what happened. And that's, in some ways, that's sensible. If, in a if a patient dies at the hospital and the doctor says, "I won't tell you what I did," you fire that doctor, right? If there's misconduct at a bank and the employee says, I won't tell you what emails I sent," well, you fire the employee. But what happens is, the lawyers of the company come in, and it's a touchy subject. They have to explain, by the way, we're not your lawyer. You may want to trust us, but we're not your lawyer. We represent the company. We are asking you questions. And if the company wants to hand your answers over to the prosecutor, they can. And so you should know now, if you want your own lawyer, you may need to get one. Some version of a warning like that needs to be given. Sometimes they'll even say, "Look, by the way, we are currently cooperating with prosecutors. What you tell us will be told to the prosecutors. But we'd like you to answer these questions." And so the employee might naturally assume that this is actually their lawyer, and it's not. It's the company's lawyer.
And these lawyers will come in, and under these kinds of circumstances, that person, in order to keep their job, might well be admitting to a crime or giving information to a crime where otherwise, if they were receiving proper counsel, they'd be taking, I'm not going to say anything here because what I say might have tendency to incriminate me, but they're not talking to law enforcement. They're talking to someone in the company. And there's some examples in your book, aren't there, where that was raised in court, where the employees gave information that was incriminating to them, but it was somewhat coerced.
Well, what the judge said in some cases in New York was that the company had actually said, basically, if you don't talk to the prosecutors, we're not going to pay for your lawyers anymore. You can bankrupt yourselves defending yourself in this case, but we're going to cut off your legal fees. We're going to completely cut you loose unless you tell us everything, talk to the prosecutors, cooperate. And the judge said that was going too far. That the company had a practice of always paying its employees legal fees. You can't just cut them off to force them to cooperate. If you do that, you're basically acting as an arm of the prosecution. That said, if the company had just had a policy all along, we never pay our employees legal fees, then there wouldn't have been any problem. Most companies wouldn't do that, though. They want employees to work there knowing that if something came up, they would be protected.
We're here. I'm George Yates. This is Justice for All. We're here with Professor Brandon Garrett, and we're talking about his book, Too Big to Jail. Who do you think over the course of, was there anybody then, would you say, in your research over the course of the last 7 or 8 years, individuals, do you think that the government might have had a case against that were not prosecuted or was not prosecuted? We've talked about banks and we've talked about Barclays that has a deferred prosecution, but I don't think there's been any high-profile prosecution since 2008 of anybody that might be responsible for this financial crisis. AIG is in litigation right now. They're suing the government now. But who should have been prosecuted, in your opinion, if anybody?
That's a question I really can't answer because there haven't been prosecutions of companies coming out of the financial crisis either. There have been plenty of mortgage fraud prosecutions, but typically lower level people who applied for mortgages fraudulently, they're not the ones we think caused the financial crisis.
Right.
Even if some people may have taken out mortgages they should have known better on, or even some of the people handing out the liar loans at smaller mortgage loan outfits, they're not the ones we think almost destroyed the world economy. But the big cases brought against banks coming out of the financial crisis have been civil cases, civil settlements, precisely because prosecutors said we just don't have enough evidence that there were crimes here. And same with the bond rating agencies that rated these as whatever AAA, subprime mortgages. There was plenty of evidence that employees knew that there were serious problems. My favorite was, I think, was it S&P? One of the big bond rating agencies had an employee that did a version of the Talking Heads song "Burning Down the House," and actually did like a video and sent it to employees as a joke of how it has spoof lyrics about the housing market about being about to crash, and the whole house is going to burn down, but we'll keep selling this stuff. And so plenty of evidence that dark humor, funny kind of evidence that people knew that something was wrong. But prosecutors apparently concluded they just couldn't prove fraud, that other people knew about it. I don't know why they didn't feel like they could prove the criminal case. They've been able to get huge multi-million-dollar settlements in these civil cases. But those civil cases, it's really hard to tell from them, do they have any evidence against particular people? You don't have detailed statements of facts like you might in a criminal case saying that this is employee A did this, supervisor B did that. You don't have even detailed breakdowns of, why did they get fined $5 billion or $7 billion or $1 billion? Where did the fine come from? None of it is really transparent. These civil settlements, whether they're in court or out of court, just don't have the same detail that you tend to see in the criminal cases. So it's really hard to look at those and say, oh, the prosecutors really caved in. Or, oh, wow, the prosecutors got them to pay a lot of money to victims even though they couldn't identify any particular wrongdoers. You just can't tell. Now, there are cases against big banks, other types of cases, where individuals haven't gotten prosecuted, and there are real concerns about why did that happen. But those cases have not been financial crisis-related ones. They've been other types of cases, money laundering-related cases, things like that.
Well, what about the charge that that the Obama administration was afraid of being accused of an anti-business witch hunt if it went after Wall Street? There's a law professor at Georgetown, Adam Levitin, who says that there's deep personal, cultural, financial, and political ties between this administration and Wall Street. I mean, I think that. Obama got elected largely, and in 2008, I think he was one reason he was elected was because he seemed to have more knowledge about what was going on with the financial crisis than John McCain did, and had actually formed some serious alliances with some Wall Street people early on. What do you say about that? What it all boils down to, this professor says, is that we didn't have prosecutions because no one really wanted to prosecute.
I'm not sure if I buy the conspiracy theories. It's the Southern District of New York brings a lot of the financial prosecutions, and they absolutely get their rewards and prestige out of bringing high-profile cases. And the Department of Justice can't just shut down cases because it doesn't like them. Maine Justice does exercise some control over the U.S. Attorney's offices, but they are somewhat independent. And, I think we probably would have heard something, although who knows, sometimes conspiracies are kept secret. But if the cases had been initiated and somehow there had been some order to drop the case against this bank, I think we would have known it. And, these prosecutors are often extremely impressive, straight arrow people who you would not expect to ever drop a case because of some political reason. Right. These are incredibly tough prosecutors, and they've been bringing other cases against many of these same banks for years. After all, like I mentioned, some of these are recidivist banks that have been prosecuted for one thing or another, increasingly, with bigger and bigger fines. And so it doesn't seem like there's a reluctance to go after big companies or big banks. If anything, there's less of that. Now, some of the lawyers for these banks say, look, the federal government was in-house inside these banks starting at the financial crisis. There are regulators there every day within the building, watching over everything, approving every deal. If they had come across evidence that there had been fraud, they would have known it because they're looking over our shoulder every second now. And that could be true or it could be not true. It's certainly true, though, that the more that the banks have been regulated, the more they're enmeshed with regulators. And the more you do worry about not as much too big to fail, but too big to jail, that there may be a concern with coming down too hard on these institutions that the federal government is so intertwined with, because the government was so involved in those first few years with just sort of bringing the financial system out of the hole that it had fallen into.
Well, it sounds that there was this, in Joe Nassaro's article, he mentions there was a New York Times Magazine article in May where the accusation is really being made that the Southern District of New York's, their focus is on the easier cases. That if they want to get their their high-profile prosecution. They go after the insider trading ones that are easy to prove, and they're basically saying that it's just it's quite simply implausible that the only person ever convicted for a crime in the mortgage fiasco was some mid-level executive from Credit Suisse. That all these other people have just walked, and like you said, there's all kinds of accusations that the trial skills of the government just aren't what they ought to be, or they take the easy cases and they don't want to go after these hard cases. And it may be just like you said, it's just too difficult to root out the wrongdoing because it's so buried within the operation of the company.
But of course, if you invest more in looking for the wrongdoing, maybe you'll find it. And in plenty of these cases, they put pressure on the companies to turn over the documents and to show us who did what. Maybe if more pressure had been put, they would have learned more about what had happened. It's hard to know afterwards, and at this point, we may never know.
In the last, let's say, 3 to 5 years, are you saying that the criminal prosecutions are virtually all of them now deferred prosecution agreements as opposed to actual convictions? Is that what you're seeing mostly now?
Well, the more cases result in convictions against companies. But most of the big cases, the cases involving the big public companies, the cases involving the multi-million-dollar fines, Fortune 500 companies, most of those are deferred and non-prosecution agreements. And so there are a lot of, when a grocery store gets prosecuted because its pharmacy was selling Sudafed illegally, maybe they'll be convicted. But the big companies that say, oh no, we're very worried about our reputation, they're the ones who are more successfully getting leniency. That does sit a little odd too. Even among companies, it's the biggest and most powerful companies that are getting the most lenient deals.
I do a lot of federal court work and a lot of federal criminal sentencing, and one of the main, if not the number one concern for a judge that's making a decision as to what a sentence ought to be is the signal to the public. We talk about, there's retribution and then there's rehabilitation, and it seems to me that what we're talking about here is nothing more than rehabilitation, as you say, a little bit of punishment with the fines, but very little example being made to others. I mean, a lot of what sentencing is well, I'm sending this person to jail because I want to let everybody else know that if they commit this crime, they're going to jail too. And isn't that the real problem with these deferred prosecutions? The punishment just doesn't fit the crime, does it? In terms of sending a signal to
it doesn't send a criminal message. Yeah.
No, it doesn't. It just doesn't, because, and I think that's it's a travesty, really, that a deferred. I mean, like I said, if you've got a child that commits a crime, and of course they're a child, we're trying to, like you say, so many of these agreements now, these deferred prosecution agreements, are very much like you would find in the juvenile court, where you've got a 17-year-old or 16-year-old offender who doesn't know any better. But when you get a 19 and 21-year-old offender these days in criminal court, I don't see too many judges that are saying, gee, I'm just going to defer a finding in your case. You're going to get a conviction. And if it's a kind of sentence, and if it's a kind of case that a judge wants to send a signal to someone else, they're going to go to jail. And I think that these deferred prosecutions, from everything that you're telling me, are not sending enough of a signal to the corporate community, and that's why they're just going to keep happening. And they know that they're just going to get a deferred prosecution because they're too big to jail. I mean, that's basically what we've got at the end of the day.
Well, you particularly worry about it where there may not be any special reason that you need to do it as a deferred prosecution. Why not convict the company so that it has a criminal record, so that if they do it again, they'll be found to have violated probation, or they'll be found to be a recidivist? These deferred prosecutions really disguise corporate recidivism.
They really do.
And you know what? They've showed us this last year in the Southern District. They've started to insist that banks plead guilty. The banks haven't gone under. They had Credit Suisse plead guilty. This French bank, BNP Paribas, which is engaging in sanctions violations on a scale we hadn't seen before, pleaded guilty. Their sentencing is coming up soon. they pleaded guilty and agreed to pay a $9 billion fine. They're not going out of business. They made sure that the regulators weren't going to take the bank's charter away. They don't want to kill the bank, but they wanted it to plead guilty because it was the most serious sanctions case they'd ever seen. But why hasn't that been done over the last few years? It seems like there was a real overreaction to Arthur Andersen, and they were bending over backwards to let companies get these really sweetheart deals. But I think we should also blame judges for letting this happen. The deferred prosecution agreements are filed in a courtroom. Judges don't have to approve them. Judges could say, I'm not going to let this case sit on my docket. I'm the judge here. Either prosecute them or don't. And, maybe we want the standard to be a little bit more strict. If prosecutors really aren't sure they have a good enough case to win, well, they should push forward and try to get a conviction, try to get a plea. Maybe some cases really don't deserve to be criminal. Well, just don't bring them at all. If the corporate lawyers are right, and some of these companies really didn't commit crimes, but they're just settling and doing the non-prosecution agreement anyway, well, maybe that shouldn't happen. But if the prosecutors really do have a criminal case, well, it should be really a criminal case. And it's hard to imagine in most cases why you really need to avoid at all costs a conviction to a company which literally can't be put in jail.
Because these prosecutions, these criminal convictions will stay on. They'll be on their record. If they do it again, then this is your second time around. And we hear this with individuals all the time. Prosecutors say, "Well, I just want to have a conviction on this person's record. So if they do it again, maybe we'll agree to probation, but we want the conviction." And I think that's what you're saying is that we need to have the conviction, and then it's on their record. And then if they're a recidivist, then you really start applying the pressure the second time around. This looks like, and this has been really, and this is the Eric Holder or United States Attorney's offices that are been appointed by Obama, and I'm in general supportive of many of these. It seems like you said, the United States attorneys they're straight shooters all across the board. I'm not maligning any of them, but I just don't understand it. I really don't, and especially since your research shows that a criminal conviction does not put them out of business.
I'm hoping that the pendulum is starting to swing the other way.
Yes.
And, I hope, when Holder is saying too big to jail, no, we absolutely will convict big banks. I hope they mean it, and that's really, and that things are really going to change.
Well, maybe with the new Attorney General, he has resigned, and maybe we'll see a tougher approach with the next AG and with the next administration. So
well, I think we'll see it soon because supposedly, if it's right that there are these new investigations of a whole number of major banks.
Are there some new investigations coming?
There's some that have been ongoing on currency manipulation.
Right.
And if that's true, it's going to be some of the same banks that were involved in manipulating the LIBOR rates or that have settled different kind of money laundering related cases. We'll start to see some recidivists in the pipeline. And, one would hope that it gets treated differently when it's the second or third time in just a few years.
Well,
it's also interesting, Carl Levin, senator from Michigan.
Right.
I think this is his finishing his last term. He's been really strong about having congressional hearings to bring in executives at major banks and corporations, whether it's tax shelters or financial fraud or money laundering, to really subject these executives to grilling, to get them to explain who did what, who's responsible. Sometimes the only way we really know what happened in some of these major corporate scandals is because of those hearings in the Senate.
But they haven't had them yet, have they? They haven't had hearings on this.
Well, I hope that there's someone new who really makes an effort to do hearings like that. In some of these cases in the UK bankers get brought in front of Parliament, and you have executives resigning publicly after they're questioning in front of Parliament. They really get their feet put to the fire publicly, public shaming, public inquiry into what happened. And since so much of what happens in these corporate cases seems to be non-public, we don't know a lot of the details. It gets settled. Hopefully it gets settled in court, but often not in court. We should also look to Congress. If the prosecutors aren't going to do cases out in the open, then maybe Congress has to bring things out into the open.
I want to thank you, Professor Garrett, for being with me the last couple of hours.
Oh, my pleasure.
My guest for the last 2 hours has been Professor Brandon Garrett. He's a UVA law professor who has just authored a new book, Too Big to Jail. And it's a fascinating account of the corporate prosecutions in the United States since 2001, and it draws on that phrase uttered by our attorney, or just resigned Attorney General Eric Holder, too big to jail. This is Justice for All. I'm George Yates. I'd like to thank you for being with us the last couple of hours, and would like you to go out and get a copy of Professor Garrett's book, Too Big to Jail. And if you want to listen to this entire interview, if you were unable to hear the entire interview, you can go to Justice for All with George Yates on my YouTube channel and listen to the interview in its entirety. Well, once again, thank you to Professor Garrett, and we'll hope you come and listen to us again next week, Saturday from 2 to 4. This is George Yates with Justice for All. Goodbye.
Thanks so much.
Bye-bye.